I'm going to guess, being I was the first person to respond when you circulated in seeing whether there was interest in this. As soon as it came across my computer, I wrote back to Gene and expressed an interest. And that was not only because the UNLV is still in my dear friend Tom Main, when we met yesterday, and he's already the Associate Dean for Faculty Development and Research. I wanted to come out and check to see if he was doing well. But also because the topic is so important and interesting. So to get at the topic today, the importance of this kind of topic, I want you to think about what law and psychology would have been like 85 years ago when I thought I graduated from law school, or even 40 years ago when I graduated from law school. In those days, if you talk to trial lawyers, what went for psychology was a lot of sort of common sense notions about the way in which people behave. Who do you want on your jury? What do they look like? How do witnesses behave? How do you determine the truth? But the common denominator of that common sense was there was no real science behind it. And it was all intuitive, and my father's intuitions were probably quite different from mine. What is so exciting to fast forward to today, and what we can hear from these panelists, are that decisions about what's going on in a trial is so much more informed. That psychology and the study of the way in which we behave has given some real insight into the way in which lawyers interact with juries and witnesses and the like. With that, I am going to keep introductory remarks very short because we agreed that you all can certainly read the biographies of these distinguished presenters. Our first is Sid Beckman, and he comes to us from Tennessee. Sid? Thank you, Michael.
I'm both excited and challenged to be here. I'm excited because I love this topic, but I'm challenged because I'm a law professor and doing anything in 20 minutes is just about impossible. So I'm going to start with a little story. A friend of mine stopped me the other day and he said, I want you to hear my story. I said, okay. He said, in my story, Sammy's mom has 3 children. Penny, crowd, Nicholas, and I looked at him and I said, Quarterman? He said, no. Let's try again. He said, in my story, Sammy's mom has 3 children. He said, Penny, Nicholas, and I said, George. He said, no. Now you see, the point of this story is you have to be a careful listener. And I'm sure you understand. Y'all got the answer right. You care? Got the answer? Yeah. Let's try again. In my story, listen carefully. In my story, Sammy's mom. Yes. 3 children. Now, that's pretty amazing. And I use that story, I have to tell you, I use that story in class. I use that story in class to tell my students that we have to be active listeners. But the key behind that is manipulation. To use your words, to use your voice inflection, to use body language, to manipulate an answer, or manipulate the response. And that's really what we're talking about here today. So why this topic? I want to take it real quick. I have an undergraduate degree in psychology, so I've always had an interest in this area. And I spent almost 15 years as a trial lawyer, trying cases before judges and juries. And I've done hundreds and hundreds and hundreds of trials. And you're always trying to figure out how to get better, how to get better. And people talk about picking a jury and how we deal with juries. And our goal as lawyers is, let's face it, we want to win, so we want to manipulate juries. I mean, we're ever really after the truth? No, we're after victory. That's what we're after, particularly this trial. And then I spent 9 years in full-time education, and then 16 years as a magician. And what tied all this together was some studies that came out. And one, in fact, Psychology Today, where it talked about how magicians are great at manipulation, right? And how you can manipulate people. They do it all the time. They do it all the time. So that's really what led to this. So I want to start out, and I'd like you to watch this brief video. video. Now, this video is only about 20 seconds long, so you have to pay very, very careful attention. Think about what you saw. How many of you saw a broken side mirror hanging down? Anybody? Okay. How many of you saw the broken headlight? Anybody? Not okay. Raise your hand. It's okay. How many saw the broken headlight? Couple. All right. Couple saw the broken headlight. Guess what? You may have been manipulated. There was a broken side mirror. Not a broken headlight. So how are you manipulating? The words manipulating. Now, we're running out of time, so I want to put this here so let's get to it. This fairly long paper has been published in Southwestern Law Review, so if you want it, feel free to find it there, or I'll email it to you wherever you find some interest. So the overall hypothesis is this: words used to form a non-leading question can influence an answer. Why do you say non-leading? Because in trial, right, generally you don't ask leading questions, certainly on your side. So how do words impact answers? Now, the car wreck video we just saw, how many of you saw a broken side mirror hanging down? That was the question, right? So how is that manipulated? That's what you have to ask, right? How does that manipulate those words? Use of the article A. You left the question open. How many of you saw A? Doesn't suggest that it exists there, but simply asks, does it exist there? Everybody with me? Okay. Now let's do this one. How many of you saw the broken headlight? Use of the article the presume the existence of a broken headlight. The difference. The former question inquires whether or not it existed. The second presumes it existed and simply asks, did you in fact see it? So you see how the second question can manipulate your answer. And we do it all the time. And it's even more plausible when you have somebody that's on the witness stand. How many of you have ever served as a witness? I've served as a witness, both an expert witness and a party. And before I was in law school, I was in a personal injury and car wreck, had some insurance company. And I have to tell you something. That's pretty nerve-wracking. When you're, I was pretty young, college age. Well, if you've never, as a friend of mine likes to say, if you've never looked down the mouth of the beast, right? I settled more cases on the courthouse steps than I ever did mediation. Because when you're walking in, when it's really real, that's when it impacts you. So these are two researchers, and I actually read this study back when I was in college. It's an old study. Loftus and Zane, or Zane, I like to say Zane. They actually posited that the former question, right, contains two inquiries. One, did a broken mirror exist? And two, did you see it? So in answering that first question, you had to go through two different analyses. Right? And of course, the problem is that the video, much like reality, occurs in but a few seconds. So you see really bad wreck. You think, well, yeah, broken headlight, I see it. You're trying to be honest. But even in your honesty, you can be manipulated. Findings. Regardless of whether an item was actually present in the film, subjects presented with a question using the indefinite article A were twice as likely to respond, I don't know. Because it didn't presume for them the existence, right? Subjects who were asked the question that used the definite article the tended to commit themselves to a yes or no, as opposed to I don't know. Here, when the object was not present, such as the broken headlight. When A was used, yes occurred 6% of the time. When B was used, yes occurred 20% of the time. That is statistically significant. That is powerful. That is manipulative. Right? So, misdirection. The coins. I use misdirection with my words, with my emphasis, with my hand gestures. Right? I skip right past. Remember the old one? There's an old one I remember as a kid. It was, okay, you're the bus driver, and it goes, and you drop off 3 kids, and you add 4 kids, and you go through this 4 or 5 times, and they say, who's the bus driver? And you're doing all the math. And the first thing I said was, you're the bus driver. Right? It's the same thing. It's misdirection. So let's look at some more examples. Another brief video, very quick. So in a study, they asked a question. They showed a video, wouldn't that be, of a car running into a brick wall. And they changed the verbs, asking them to guess the speed. Now this will blow your mind. How fast was the car going when it contacted the wall? 31.8 was the average speed of all the subjects. But when they asked how fast was it going when it smashed into the wall, the speed became 40 miles an hour. Look at that speed difference over many subjects by the changing the verb. So my background, I'll just tell you, my background is family law. So the cases I tried were lots and lots and lots of divorces. It's a little different here in Nevada for those of you who are local. But in Texas, we have the great claim. Anybody know what the difference in Texas versus any other state in the union is with regard to family law cases? Juries decide custody. Yeah, think about that. It's not mandatory. It's not mandatory. You don't have a judge do it. But you can also, no other state in the union does that. So, you put somebody on the stand, you're talking about, well, what happened when he slapped your face or hit your face. Or, the verbs we use to describe events can impact the answers and impact the listener, which is the jury. Here's some more. When it hit the wall, it went up. When it bumped the wall, believe it or not, versus it went up. When it collided, it went up. And it smashed. Right? So you can see that changing the verb impacted. So their conclusion, the form of a question, in this case, changes in a single word. A single word. And markedly and systematically affected witnesses answer that question. Here's some other. There's a bunch of different studies, by the way. And many of them are in the papers, so if you have an interest, you can find them. So how much time did the man have between lines? Now this study usually called modifiers and marked modifiers. And marked modifiers are one that would impact or influence the answer as opposed to the neutral one, which they said would. How little time did the man have between lines? Now, in their study, their argument is if you say how much, it's an open-ended question. If you say how little, it actually sort of sets the bar if you're looking at the floor. Okay? That's how they look at it. In this case, how much time? The estimate, this was an average, 73.2 minutes. How little? 37.5 minutes. Look at that difference. By changing one word, nothing else, no other information, changing one word impacts the answer. How heavy was the set of weights versus how light was the set of weights? 146.3 pounds, how heavy? 56.3 pounds, how light? Huge changes. Right? Almost 100 pounds. How high was the plane flying? Indeed, off the ground. How low was the plane flying? Almost 9,000 feet versus almost 4,500 feet. So, actually, I'm going to take good only get time. So, obviously, we can't go all into all this in 20 minutes, but this is sort of what is set out in the paper. Use of words, misdirection, misinformation, time delay, dialects, age, gender, and verbal cues, inattentional blindness, the written word, which we're going to talk about for today, and potential preventative measures. Inattentional blindness, I want to focus a minute on that because there's a famous video that probably all of you have seen. It's on the internet. You're talking about the gorilla, the gorilla, right? I'm pretty observant, I have to tell you, I think. Particularly, I have a background in magic. And years ago, it was sent to me, and I watched it, and I counted. So they said, did you see the gorilla? I'm like, what gorilla? I confess, didn't see the grill. And you know, they're not playing a trick on you because you play the same video again. So there's no real question. And then you see this guy, grills, he's dancing, you know, but they're playing basketball. And, you know, he stops in the middle and he keeps going. And I don't remember how long the video is, 2 minutes. And this gorilla's in for half a minute. Inattentional blindness, meaning you're focused on your task and you therefore are blind to other things around you. How many of you have gone down a street, you just went down because you're looking for a house or you're looking for a destination, and you're driving back like, this isn't the same at all, right? It's inattentional blindness. We can focus somebody's attention using our words. Those words. Count the number of passes between the players with shirts. And then your focus and your mind is focused on that. Right? So this is this kind of thing that we can do to manipulate answers when we ask questions. And although there haven't been a lot of studies in the context of trial work, and of course it's harder to do that sort of thing, I think what it shows us is there's just this unbelievable ability to influence and impact answers, which may not be a good thing. So that study, for example, talked about how tall or how short. It didn't ask the question, what was the height of the man? See, to me, that's really neutral. Right? What speed was such and such going? So those are all sorts of things. Now, one of the other things that actually really hasn't been a study on it, but I thought was interesting is dialects. And this is probably wasn't my answer. So you can indirectly suggest a response, create a framework in which response answers, set boundaries or limits, misdirect the attention of the responder, and then play on minds. They can play on minds, tendency to fill in gaps, which we tend to do. So I want to just give you a little example of dialects. And it's a silly one, I will tell you, but I teach evidence primarily, and I tend to use this particular movie, which I'm sure most of you will be familiar with lots of different clips. And this one, I think, talks about dialects and how dialects may impact certainly the listener when we're dealing with different dialects. And if you ever brought in, I'll tell you, I had real experience with this. I brought in an expert witness from New York City to talk to the Texas jury. No offense, but I spent 2 days working with him on the way he said things, because you got to do things a certain way in Texas. And when you're from New York, sometimes it doesn't work so well. So let me share this with you.
Mr. Pitt, when you viewed the defendants walking from their car into the sacrifice, what angle was your point of view?
They was kind of walking toward me when we entered the stand.
And when they left, what angle was your point of view?
It was kind of walking away from me.
So would you say you got a better shot of them going in and not so much coming out?
You could say that.
I did say that. Would you say that?
Yeah.
Is it possible the two youths,
Two what? What was that word?
what were it?
Two what?
What?
You said youths.
Yes, two youths.
The youth.
Two youths. Is it possible the two defendants 22 specific items?
So it's a funny example of dialects, but we should be cognizant of that too, because that certainly can impact the way. I mean, I will tell you, rarely, unless it's a hostile, truly hostile witness, rarely will a witness say, I don't understand what you said. They tend to answer. Unless they're really hostile, in which case they pretend they don't understand anything you say. So that's how we do it. So anyway, thank you. I am under 20 minutes.
If we keep up the good work of staying under time, we'll have some time for questions. Our next speakers come to us from the University of California, Davis, and they are Daniel Venerian Gardner and Deborah Hobart.
Good afternoon, everyone. Dan and I are actually both doctoral students in developmental psychology, so we're going to be introducing a whole other branch of psychology to the mix here. What we're going to be talking about today are whether or not jury instructions prime jurors to pay attention to emotion. Now, as a litigator in my past life, I actually grew up on those war stories Michael was talking about, and I didn't go to law school, what was that, 50 years ago? But I grew up, some war stories I did grow up on, are these ideas of what do we do when we have emotional evidence? Do you call it out to the jury and have them just pay attention to that evidence, right? Some lawyers say, don't ever do that. It's the white elephant in the room, let it hang, move past it. Other lawyers that I grew up with would tell me, you know what, you need to warn the jury that this is coming. Emotional evidence is hard to take. We've heard about the negativity bias. You want to sort of give them a chance to preface themselves and give a little bit of room. Well, that's something we wanted to answer. It's sort of an empirical question. There are many of them in the law, as we all know. And we wanted to look at emotional evidence from witnesses. Now, emotional evidence can take a lot of forms. The form that we're going to talk about today is this last witness, the child witness. And there are two reasons we're looking at the child witness. The first being that Dan and I both care greatly about children in the courts. It's something we're passionate about. It's an area that we both think needs more work and we encourage people to do. Second, child sexual abuse cases give an interesting paradigm for credibility in witness cases because often the child is the only evidence being offered as to the credibility, as to what's going on, as to the ultimate decision. So we use this paradigm here to look at how emotion affects the ultimate decision. What do we know about child witnesses in sexual abuse cases? Well, most of the research that's been done so far is done during disclosure. For instance, at a forensic interview center or during a police interrogation of some sort. And we know that the most common emotion is neutrality. It's actually not sadness, it's neutrality. And this is true across the witnesses based on gender or their age, which is quite surprising because we have a lot of assumptions about gender that hold into child witnesses. Less work has been done during testimony, but the work that has been done shows that 65% of children show some distress, but it still leaves us with a full 35% of children who are fairly neutral and don't show any distress at all. What do we know about the way that jurors perceive children's emotions? Well, jurors expect that children will cry and be sad, and that they are few children is more credible when they cry. But they expect them not to be too sad, and they expect them not to be neutral. So what do we do with this? We have this conflict here, right? We have our children who are testifying, and they're doing so in a way that's different than what the jurors are expecting. Well, as lawyers, we have a few options open to us. We have the expert witness. You can call someone like Dan or myself, or you could definitely call someone like Dan or myself to testify about the prior research, what children do, what we expect out of them. The other option is the jury instruction. And we're going to focus on the jury instruction here for a few reasons. First, to be honest, the jury instruction is cheap. It's free. Everyone can do it. Expert witnesses are expensive and hard to use. Second, many states, including California, actually require, mandate that a jury instruction be given when child witnesses testify. In California, it's for criminal cases where children are under the age of 10. And this is some of the language here. You'll see that they tell the jurors to consider all the factors surrounding that testimony, including the child's age and level of cognitive development. There is, however, no reference to emotion whatsoever in the instruction. And so this California pattern jury instruction is the one we're going to use in our study, and Dan will talk to you more about later. So jury instructions help. Well, all the work so far is focused on child's cognitive abilities, which is why a lot of the instructions focus on cognitive abilities. And it has shown that instructions given prior to a child testifying do help frame the issue for the jury. And actually, the children are viewed as more credible when they receive that instruction. However, we think that emotions may be different because of these prior biases and these prior ideas that individuals hold about children and child witnesses. And that's what we seek to test today. We want to analyze whether a carefully crafted jury instruction can alleviate some of these biases. We also want to analyze whether the effect of the instructions offered before or after the child testifies. And Dan will tell you a little bit about the way we tested this.
Thank you. So this is the time for that math in the middle. Hopefully you'll stay with me to get to the end. So basically, in order to achieve our goals, we presented a summary of a child sexual abuse trial to 465 undergraduate participants, mostly female. Basically, so the scenario always started with the child witness's testimony. which went something like this. I thought I'd have a computer in front of me, so I'll try and read it off the screen, give you all an idea of how it sounds. John Reed, a 30-year-old single male teacher, has been accused of several counts of sexual assault by his 5-year-old male student, Sam Martin. So this version is of a 5-year-old boy. However, we did vary to different scenarios, and I'll explain that in a minute. After seeing the opening of the scenario, what they were presented was a picture of said victim. The picture was presented on the screen for about 3 seconds. The scenario then continued, and they were presented a picture a second time. This is just to ensure that the picture was really relevant, given that we were using pictures to represent the emotion of the child. There was then testimony from 4 other witnesses: the mother of the victim, the defendant, a teacher's aide, and a principal. There were also 2 pictures, neutral pictures, of each of these witnesses. So as I said, that was one example of a scenario they could have gotten. So each individual participant only saw one type of scenario. That scenario was varied by the age of the witness, either 5 or 13, the gender of the witness, male or female, and the emotion displayed. Prior to using the pictures in this study, we piloted them to make sure that they were indeed displaying the emotion we were hoping to convey. So we had a set of undergraduates rate the pictures of the different emotions, and it turned out that the neutral picture was rated as the most neutral picture. The sad picture was rated as sad, and the teary picture, crying picture, which was basically the sad picture with tears added onto it, was rated as significantly more sad than either of the other 2. So the pictures were indeed conveying the sadness we were hoping they would. All participants got, either prior to seeing the scenario or after seeing the scenario, 1 of 3 jury instructions. The first one, which is the emotion absent, was the one based on the California pattern jury instruction and makes no mention of emotion whatsoever. The emotion reference jury instruction basically just added a statement to the effect that the child's demeanor and emotional reactions is something to be considered, but didn't in any way say how that should happen. The emotion elaborate jury instruction basically mentioned some of the findings from the research, and basically we added a section saying that the child's emotional reaction may be different compared to an adult, and that the child's emotional reactions do not necessarily mean that the child is lying or telling the truth. You should not discount or distrust the testimony of the child solely based on how the child emotionally reacted. So all participants were asked a series of questions relating to the scenario. We're just going to focus on 2 of the questions for this talk. One of them was to rate the victim's credibility, which they did on a 6-point Likert scale, from completely unbelievable to completely believable. They were also asked to render a verdict of not guilty or guilty. So I'll go quickly over the slide. We did an ANOVA, putting in the victim emotion, victim age, instruction order, and instruction type as our independent variables. And then we did a logistic regression where we tested 2 models using those same variables, but also adding victim credibility. So what did we find? Well, with regard to order of instruction, it actually matters. We found a significant pointer. Can anybody see that pointer?
Yep.
Okay, great. So participants who got a jury instruction after seeing the scenario rated the child as actually being more credible. With regard to the type of instruction, so there are 3 types of instruction, we actually found an interaction between the type of instruction and the emotion displayed by the child. So for participants who got the emotion absent during instruction, so no mention at all of emotion in that instruction, they actually rated the sad child as being the most credible, which is in line with some of the research Debbie mentioned earlier about credibility being associated, sadness being associated with credibility. However, with the emotion elaborate jury instruction, the crying child actually became the most credible, then the sad, and then the neutral. With regard to guilt ratings, what we found was neither the type of instruction nor the order of instruction actually predicted guilt. However, credibility predicted guilt. Basically, what we found was that for every 1 point increase in credibility on that scale, there was almost a 5 times increase in the likelihood of voting guilty. So obviously, credibility is an important factor in deciding guilt when it comes to these type of cases. So to summarize our results, jury instruction order predicted credibility. Jury instruction type interacted with victim's emotional display in predicting credibility, and credibility predicted guilt verdict. So Debbie is now going to tell you what this all means and where we're planning on going with this.
I can't actually tell you all what it means exactly yet. That's the goal for the future. But what I can tell you is that we do have some evidence that the jury instructions do prime the jury to pay attention to the child's emotion, right? Order of presentation matters, and the particular instruction offered actually matters. And instructions that not talk to the jury about emotion resulted in large group differences based on the pattern instruction. Now, why did the emotional elaborate instruction result in differences when one would think all that discussion would help give them a good framework? We think it's because we talked about the children's emotional reactions, thus implying that there should be an emotional reaction and normalizing an emotional reaction. So one of the things I'll talk about soon is that we're going to do that in the future and try to tone down that language a little bit. So how do we know this is priming, to use the more psychology term for it? Well, we're looking at that issue. What is the cognitive process underlying these differences between the instruction received and the ultimate way the child is viewed as to credibility? We're analyzing differences in perception and interpretation. Do the jurors actually see the child as different, or do they just think the child is feeling differently? We're analyzing individual differences in jurors to see if that makes a difference in their ultimate ratings. So the lawyering decisions, right? What do we do with this? Do we not present an instruction at all? It's not at all what we suggest at this time. We do know from prior research that instructions help with the cognitive capabilities of children. And we think there's additional steps that we need to do before we can reach a final conclusion, including looking at fully neutral instruction with no child reference whatsoever, rewriting the experimental instruction, one with the emotional elaborate, to remove any idea that neutrality isn't an accepted response. Looking at the effects of deliberations, we'd be curious to see, once everyone gets in a group, how they discuss this and what the outcomes would be. And finally, to look at emotions other than sadness, because sadness is just one of the emotions that children display on the stand, the others being anger or some sort of guilt or shame. So finally, we'd like to thank all the people who make this possible. As everyone knows, research is not a singular practice. We'd like to thank our advisor, Dr. Gail Goodman, all of our colleagues at the Developmental Research Center who do solely apply developmental research with the law. And finally, we'd like to thank two of our RAs, Kimberly Cressida and Jessica Ross, for all of their help with this. And we'd like to thank all of you. So thank you very much.
Good afternoon. Today I'm going to talk to you about the art of examining the child witness. Every successful attorney must master the art of examining a witness, but child witnesses are unique. Therefore, they require a different skill set. How is the child witness different? There's multiple developmental factors that have to be considered that interact with one another and are all hinging upon the child's age and developmental status. Child witnesses are vulnerable. They are sympathetic, and there's an increased sensitivity about subject matter when examining a child. In other words, children are fragile. Developmental factors that have to be considered when examining the child witness involve emotions, cognition, behaviors, and social factors. All of those are interacting with one another and all depending on the child's age and their developmental status. If you learn to understand these various factors and how they can impact a child's performance, testifying as a witness, you can improve your effectiveness as an attorney. You can make the experience less traumatic for the child, improving that child's ability to participate in the process, which enhances the justice process overall. You can be perceived in a more favorable light. In other words, judges and juries do not like attorneys who make children cry. You can use techniques that will elicit the desired response and learn how to avoid techniques that are unlikely to do so. And you can recognize the techniques that are being used by others and, if necessary, critique those. And you can improve your ability to react to the child witness statements on the stand or in a deposition. The first factor that I'm going to talk about is cognitive. Memory is a huge part of the cognitive factors with children, and it's important to understand from the get-go that memory is reconstructive versus reproductive. And what I mean by that is that when we are talking about memory, we don't pull out a mirror image of what actually happened. We actually rebuild that memory at that point in time. And it is internally flawed. It is prone to errors at every stage, from encoding, storage, and retrieval. And I'm also going to talk about the issues of suggestibility, repression, and amnesia when it comes to child witnesses. With regard to encoding errors, I want you to understand a phenomenon called script-based knowledge. Script-based knowledge is the brain's tendency to fill in the gaps with assumptions about what it thinks it knows. Now, if a child's emotional state is high at the time of an event, again talking about encoding, that child's brain is going to be limited in its ability to encode a lot of the data. And so it's going to encode very little, and the brain is going to fill in the gaps with what it thinks it knows at the time of encoding. This is also true during storage. When a memory is sitting in storage, script-based knowledge occurs. And the longer a memory stays in storage, the more likely this can happen. Also at the point of retrieval. This is particularly true with sequencing. For example, if a child normally sees the next door neighbor in the front yard on the way to school every day, that child will most likely use script-based knowledge to fill in a gap. And recall, seeing that neighbor in the front yard on the way to school on a given day, even if that neighbor was out of town. That's script-based knowledge. The child's not lying, the child truly remembers that, but it was script-based knowledge that filled in that gap. With regard to memory storage, again, the longer the passage of time, the bigger the opportunity for error to come into play. The number of recalls that a child has between the event in question and the actual examination is important. If it's a high number of recalls, if those recalls are free of influence or intervening or interfering variables, that's going to increase the accuracy of that child's recall at the time of testifying. However, if there are interfering or intervening variables, such as a tainted interview that occurred in between the time of the event and the time of testimony, that is going to decay the accuracy or integrity of that memory. With regard to retrieval, script-based knowledge is again of concern, and you also have the issue of motivation with children, both conscious motivation and unconscious motivation. It takes cognitive effort and energy to remember something. If a child is not motivated to cooperate with you, they are not going to be motivated to remember. If a child wants to avoid recalling traumatic events or things that are upsetting to them, they may not be motivated to engage in that cognitive task. Also, subconscious motivations. If a child, particularly a young child, is tired, hungry, cranky, afraid, they're going to be less able to engage in this task of retrieval. Retrieval is most accurate when the circumstances are similar to the time that the event happened, the emotional state of the child is similar to the time of the event. If the subject matter was highly familiar to the child or highly bizarre to the child, recall is going to be better. The use of cues and prompts can be helpful. And again, a short passage of time. You want to examine the child as close to possible as the event in question to get the most accurate retrieval. Let's talk about suggestibility, because this comes up a lot with child witnesses, particularly in cases of abuse claims. Younger children, as compared to older children, are much more susceptible to suggestion when it comes to details. And so things like, did it happen in the day or the night? Was the dress red or black? Was it a car or a truck? Young children are highly susceptible to suggestion. But when it comes to the issue of abuse itself, whether or not abuse occurred, the research does not show us those same age differences between the younger children and the older children. That is something that is surprisingly highly resistant to suggestion, which is interesting because that's a common strategy used to combat child allegations of abuse, is this issue of suggestion that may have occurred with a mental health provider, may have occurred with prior interviewers. But you need to understand that that's actually unlikely going on when you're talking about the actual issue of abuse. But with regard to details, absolutely. Young children, highly susceptible. The issue of repressed memories is controversial in the field and is really irrelevant to children because they're not old enough to have engaged in that process. But what is important is the issue of infantile amnesia. Infantile amnesia refers to a child's cognitive inability to form what's called an autobiographical narrative prior to about the age of 3. It takes a child about the age of 3 to be able to have a concept of self and life story and events that have happened to him or to her. So if you have a child testifying about memories of things that occurred prior to age 3, the accuracy of those memories is rather dubious. On the flip side of that same fact, if you have a child who cannot recall things that happened before age 3, that should not be interpreted as meaning that the things did not happen. The child probably would not have memory of things that happened at that point in their development. So what do we do about these memory problems? I want you to recognize the potential for error in their sources and accept that some degree of error in memory is inherent and normal. Examine the child as early as possible for best recall and elicit the help of a qualified mental health professional. And I'll talk a little bit later about what I mean by that. But doing so can help avoid unnecessary repeat interviews of a child, which can be traumatic. It can help to preserve the integrity of a child's original memory, increase your likelihood of successfully securing the information that you need, improve the accuracy of your interpretation of the child's responses, and can help you meet Daubert or Frye standards depending on the state that you're practicing in if you plan to submit the interview as evidence. Another cognitive factor we need to talk about is language when it comes to children, particularly young children. Expressive language, what they're able to say, and receptive language, what they understand that you're saying as the attorney. Young children have a limited vocabulary and they have poor comprehension of the vocabulary that they do possess. They can use unique slang that is not readily understandable by adults. And young children engage in storytelling and fantasy on a routine basis. They blur the lines, young children, between fantasy and reality. It's very common for them to tell a story about what happened and for elements of fantasy to creep in. What do we do about this? The use of visual aids and props can be helpful to allow a child to demonstrate something if they're not able to find the words to describe it. You can ask them to act out or demonstrate what they're talking about if you don't understand. And be highly directive in your questioning with a child, a young child, because if you ask them to tell you a story about what happened, a story is exactly what you're going to get. And before you know it, unicorns are involved. Receptive language. Children can engage in what's known as confident inaccuracy. You may not, as the attorney, realize that the child does not understand your question because of the degree of confidence that they answer with. And so you have to consider that where does the child spend most of their time? In a classroom. And there's lots of things they learn from a classroom setting. When a child doesn't know an answer, guessing is encouraged. It's certainly not penalized, and they're encouraged to do it. And so children guess answers all of the time. There's also the issue of adult legitimacy. What this refers to is, if you provide a child with a question and a set of possible responses, the child will tend to pick from that set of responses, even if they think the answer lies outside that set of options that they're given. Why? Because you're an adult and they trust you. And so this phenomenon of adult legitimacy makes them think that if you're giving them a selection of answers, the right one must be in there somewhere. Similarly, if you ask a child a question like, what color of hat was the man wearing? A child is going to assume legitimacy to that question and that there must have been a hat. Even if their memory doesn't recall that hat, they're going to give you a color. They're going to say black or red instead of there was no hat. Because you're the adult, there must have been a hat and they must be wrong. So be aware of that. That can sometimes hurt or help your legal strategy. If you're not sure that a child is understanding what you're asking, ask the child multiple ways the same question, but do so before the child has an ability to respond. This is because of those classroom expectations. When a child answers a question in class and the teacher asks that same question again or in a slightly modified way, what does it imply? It implies that their answer was either incorrect or insufficient. So if you're asking a child a question, even if it's slightly modified multiple times, the child will adapt and alter their responses each time, trying to get that accurate or sufficient answer for you. If you're not sure that the child is understanding what you're talking about, ask him or her to restate the question in his or her own words, and remind the child repeatedly that I don't know, or I don't understand, or I don't remember are perfectly fine answers, and be very careful with your phrasing. Children are very concrete, young children. My favorite example of this from a case I was involved in was a little girl, and she was asked a question by one attorney, are you in school? To which she said no. Now, a big issue was made about this because the whole purpose of the trial involved an event that happened at school. And so the attorney said, well, she lies, she's not credible, we can't continue this. The other attorney gets up and says, what grade are you in? And she says, second. He said, then why did you tell the other attorney you're not in school? And she retorted, well, I cannot be both here and there. She's very concrete. And so practice Practice your phrasing with children before you examine them to watch for those kinds of nuances. Emotional factors. Children can experience a variety of emotional factors while testifying, ranging from anxiety, fear, shame, conflicted feelings, guilt, whether rational or irrational, and they may have other mental health diagnoses that come into the picture. Causes of anxiety for children in the courtroom, especially young children. The courtroom itself is large, the furniture's oversized, it echoes, it's kind of scary. In the legal process, if an attorney yells objection at something the child says, the child's probably going to interpret that they're in trouble, that the attorney is mad at them, if they've done something wrong. So they also can be anxious about public speaking, the performance of their testimony, strangers, and authority figures. Solutions for this involve courtroom modifications, exposing the child to the courtroom and the legal process ahead of time, and even giving the child very small choices can help increase their sense of control over the process and lower their anxiety. So asking the child's witness, would you like to take a break in 1, 3, or 5 minutes, is going to increase their sense of control over their experience and help them to better able to participate. Allowing small children security items like teddy bears and blankets is a good idea, or a safe person like a parent or a therapist within visual distance. And some children, if they're highly anxious, may need psychotherapy to be able to fully participate in that process. Causes of fear. The most common cause of fear in a child witness involves facing a perpetrator. They can fear immediately for their safety. They may fear retaliation for their testimony, which is a common threat used particularly in abuse situations. And they may have a re-experiencing of the trauma in the presence of an accused perpetrator. Solutions to that. Use a screen to block the child witness's view of the accused. Position them strategically to where they're facing the judge, or direct them to only engage in eye contact with the questioning attorney, or transmit their testimony in from a 1 or 2-way closed circuit television. Shame, particularly true if you're working with children in sexual abuse cases, if they're required to talk about anatomy, sexual content, or participation in sexual acts. Solutions for this can involve allowing the child to use visual aids to avoid having to use words, clearing the courtroom, and restricting the media. This is very important for older child witnesses because they're very well aware of Facebook and YouTube and how things can get out on the web. And if you can ensure that witness and guarantee that they have their confidentiality protected as well as the content of their testimony, it can go a long way in helping them to cooperate with the examination process. Inner conflict. Children, especially young children, have a real hard time with opposing concepts. They don't understand how someone that they love or like can also have done something bad. And so they're torn between these two things, and guess what typically wins out? How much they love or like a person if this conflict cannot be resolved. So a child may be asked to testify against someone they have attachment to, against someone they love, possibly a parent. Solutions for this are recognizing, normalizing, and validating it, and providing the child with an opportunity for psychotherapy to resolve that conflict beforehand, preferably. Causes of guilt, related topic, breaking a promise, feeling like they've betrayed someone that they care about, or perceiving that they're actually responsible for why someone may go to jail, or why someone may have to pay a lot of money, lose their job, etc. So working with the child, again, recognize, normalize, and validate, but also debrief them after they do that so that they understand that they did the right thing. Psychotherapy may also be indicated in those cases. Other mental health conditions can range from ADHD to PTSD. If you're working with a child witness who happens to have a mental health diagnosis, you probably do want to involve a mental health consultant in that. Courtroom modifications may be necessary. Hearsay exceptions, that's how I get involved in a lot of cases, is providing evaluations of the children and then testifying on their behalf as opposed to the child testifying. Psychotherapy and pharmacology, if a child's highly anxious and anxiolytic, might help them. If a child is ADHD diagnosed, making sure that they took the medication the day of the deposition or the day of the testimony can be important for them to be able to perform well. With behavioral factors, we're mostly looking at cooperation with very young children. What can look like defiance is actually probably a developmental limitation. And if you understand what these developmental limitations are, an ounce of prevention is worth a pound of cure. You can set the situation up for success instead of failure. If a child does not want to participate, you'll see them create distractions, you'll see them withdraw, they need to use the bathroom, their tummy hurts, they may start crying or tantruming, and they may flee and become combative. Children have short attention spans. They can't sit still for very long, and unlike adults, they can't talk about the same topic for very long at a time either. They have a failure to link their immediate behavior with long-term consequences and to appreciate the significance of the legal process. They really can't appreciate how their testimony may affect high-stakes outcomes. And some of them just find the situation overwhelming and lack the skills to self-soothe or cope. So what do we do about this? Have a gentle but a firm demeanor with children. Be brief and efficient. One mistake I see a lot of attorneys make is they spend all their time using their time with the child to build rapport. Rapport is important, but sometimes I watch them do that and the child is done by the time they start to ask the questions that they're trying to get. So be brief, be efficient, get in, get out with the child witness. Allowing the child to move around or engage in an activity like coloring can make a big difference in the child's participation. Take frequent breaks, offer snacks, and do use age-based scheduling. What I mean by that is don't schedule your deposition for the child's nap time, and don't pull a child out of a ballet recital they've looked forward to for 3 months to testify. It will not go well for you if you do. If you start to lose the child's attention, change positions, change tone of voice, switch out attorneys, change the topic of discussion, and provide education and practice for the child ahead of time so that he or she knows what's expected. And you can elicit the cooperation of a parent or a caregiver to provide reinforcements for cooperation. You can do the same as long as it's for the child's participation, not based on their response. So it's okay to say, I'm going to give you a sticker for every 5 questions you let me ask, as long as it's not based on what their answers are. Social factors, we've already talked about adult legitimacy and guessing with classroom expectations, repetitive questioning. What we do need to talk about is association. Children don't have a context for the legal process or the courtroom. Mostly, if a child has seen anything about court or law, they've seen it on television. So they watched a show like Law and Order, and all they know is that people go into court and they get drug out in handcuffs screaming. You have to talk to a child and let them know they're not in trouble and they haven't done anything wrong and they're not going to jail, and really do a lot of education that you don't have to do with adult witnesses so that they can participate. Clinical versus forensic roles. I said a qualified mental health professional, and this is exactly what I mean. There's 2 different types. There's clinical and there's forensic. One is not superior to the other, but they are different. They have different training backgrounds, different skill sets, and in fact, the practices are so different that even our guidelines and principles and our ethical codes are different, depending on if you're clinical or forensic. Clinical roles are therapeutic roles. You're providing therapy, you're more subjective, you're an advocate for your client. It's largely unstructured and it is more theoretically driven. A forensic expert is not a therapist. They are an evaluator. They're neutral, they're objective, and they seek equally to prove and disprove the hypotheses about what may be happening. Conclusions. What do I want you to take away from today? Even very young child witnesses can be effective and reliable when they're examined using appropriate techniques, when their emotional distress is reduced, when the environment is child-friendly, when they're adequately prepared, when their developmental needs are considered, and when appropriate courtroom modifications are made. Further, the gist of a child's testimony can be accurate even when there's multiple inconsistencies about the details of the event. The need for courtroom modifications for child witnesses is both theoretically and empirically supported, yet rarely employed on a national level. Collaborating with a qualified mental health expert can be beneficial to help you develop your examination strategy, to help you prepare the witness, conduct the initial forensic interview to provide hearsay exceptions, can help you meet the doctrine of Frye standards if you introduce the interview as evidence, and to help you critique other individuals' interviewing techniques and interpretations, which is also a lot of what I end up doing, and to make the experience more child-friendly. And we'll talk about questions and if we have time at the end. Thank you for your time, attention, and interest.
What I want to talk about follows perfectly from everything you've just heard, and this is in many ways a great lead up. I came to the subject of witness credibility because I've spent the first 10 years of my career working with refugees and refugee cases, where witness credibility is central and typically is the entire ballgame. And the typical problems that would come up are exactly the types of things that Sarah just alluded to regarding children about the frailty of human memory. Last time you said the prison cell was 10 feet by 10 feet. Now you said 10 feet by 15 feet. So was there a prison cell at all? Probably not. And that kind of a judgment from adjudicators is extremely common. People describing the absolute worst forms of torture and infliction of pain, and doing so stoically and in mechanical detail, like they're an engineer talking about specs of the building. For many decision makers, that's very suspicious. So in that field, we had to think a lot about what exactly should witness credibility be, what can it be, what can we actually expect from people who are testifying. What I want to talk about today, I'll come back to the refugee situation at the end. What I want to talk about today, though, in a way, is possibly a pessimistic, I guess the polite word is a challenging note, about that in the area of witness credibility, there are some significant difficulties that the legal field, at least the American and possibly all of the common law legal field, may have in we may have some serious difficulties in law, in our legal tradition, digesting what's now becoming a fairly robust area of psychological knowledge about what can we really expect from witnesses and how we should judge whether they are telling the truth. Obviously, this is not rocket science. Knowing whether a witness is credible is often essential, quite often pivotal to a case. And these range from whether I ran a traffic light to whether someone should be put to death. The stakes can be small or big, and it often will come down to whether someone has both an accurate memory and whether they're being honest. And one of the things that's great about lawyers is you learn really early in law school about how to assume for the sake of argument. If you can assume things for the sake of argument, you can be a very good lawyer. Our legal tradition assumes, for the sake of argument, that we can figure this out. Because pretty much every case we will ever decide, at some level, depends on figuring out what are the facts. So we have to assume we can figure that out. And that, again, goes from the full range of pretty much everything we adjudicate in our system. And if we start to wonder, well, what if we're not actually able to figure out the facts? Almost everything else we do make us crumble around us. Because it doesn't matter if we know what the legal standards are, we can't even figure out what facts we have to apply them to. So if we're thinking about whether our system is built on the idea that there are Superman fact finders who actually can know the facts, and I would suggest that a lot of the time, we don't really think in these terms, we certainly don't use this phrase, but we act as if the Superman fact finder exists as a jury, or the administrative adjudicator, or a judge, but we treat them like, well, the fact finder has facts. And as long as there's some basis for that, we're going to treat that as if it's magically accurate. That is, we have a very romantic idea about finding the truth. It's the Perry Mason idea of law in the legal field. And it's very different from the way social scientists tend to talk about evidence and conclusions. So lawyers are much more likely to talk about truth. Jurors may very well expect to find the same when they come into the courtroom. Whereas social scientists are much more likely to have slightly more cautious wording. Things like, the evidence is consistent with the hypothesis. Which means that perhaps we can consider the hypothesis to be true for working purposes, but it doesn't rule out someone coming up with new evidence a year or two, 10 years, 20 years from now that's not consistent with the hypothesis. It's far more hedged and leaves a lot more room for doubt. Now, our common law tradition has some of this built in, but we don't always take advantage of it. We've got different standards of proof that all lawyers know for different kinds of cases, reasonable doubt, preponderance of the evidence. Lawyers think of preponderance of the evidence as more likely than not. What may be really useful about this is actually quite likely wrong. 49% chance wrong is okay enough for preponderance of the evidence, which is really pretty frightening. if you think about that. We don't think about that enough because there is actually an important value judgment in deciding we maybe can't tell for sure what happened. We need to make a decision. We're really deciding which way to err. We have this built into our system, but we don't take advantage of it very much. What we have instead is this romantic idea that we will be able to tell the truth. And the key way we'll be able to do that is by watching how you testify. Demeanor. So, we have this rationale built into our legal system. We have this, a good place when we're in whenever looking at field of evidence, it's always good to start with Mr. Wigmore. So he's got this quote that says, he basically adopted this. This is actually from an older Indiana case that found that visually impaired people cannot serve on a jury. Why? Because how will they know if someone's telling the truth if they can't see them? They can't look the witness in the eye. So Wigmore thought that was the perfect idea. Hold that thought in your mind, though. It's not, by the way, current law. But keep it in your mind how logical it is coming from the idea that I need to look at you to be able to tell. Actually, I'm the one talking. You have to look at me to be able to tell whether I am full of it right now or not. So it goes back before that. Wigmore didn't invent it. This was the earliest American case I'm aware of saying this, but I'm not the most energetic researcher. The Massachusetts court here fought, by the way, if you read the full decision, it's clear they didn't think they were the first ones to say it. I think they quoted the Bible as one of their sources, but also thought that Blackstone had said it and maybe some other older people in England. It's basically an idea that we've had built in for a very, very long time. And it would be a nice quote, I threw this point in there just to show sort of the spirit. He's not a judge, but he basically was saying the same thing. It's coming from the same idea about how the human psyche works. I will be able to squeeze the dishonesty out of you in the courtroom, especially after you've taken an oath and you're sitting in the chair and the judge is next to you. That's the theory. Now, it would be great if that were all early 20th century, 19th century, but it's not. This is a decision that was written by Justice Scalia, a pretty big majority of the court, however. This is in 1988. By this time, there was about 25 to 30 years worth of psychological research about the value, really lack of value, of demeanor in telling the truth. None of that appeared in the Supreme Court. Said, we have stories from President Eisenhower and Abilene. And the phrase, look me in the eye when you say it exists, because it must be true, since we have a phrase for it, so it must be true. And then finally, the reason that this perception persists is because there's so much truth to it. This is the Supreme Court very recently, and one more of my favorite one. You may have heard of this case. It was something about an election. A reference, again, to the idea that we can't really refine through science how to tell whether witnesses are telling the truth. Actually, why did the court actually have to say this in Bush v. Gore, which was hanging chads? The whole idea was, well, if one person judges chads differently than another person, it's an equal protection violation. That's and if some clerk realized, there might be inconsistency throughout our adjudication of facts because different people judge witnesses differently. So the court threw this in to say, this only applies to hanging chads. It doesn't apply to inconsistency from two people. You and I might both listen to him talk, and I think he's honest, and you think he's lying. But the court does not want to go into this. So we actually have an area where the court continues to abide by the same thing, looking in the eye. And go back to that visually impaired juror. That's been overruled. Because by the late 20th century, it just didn't sit right. It seemed wrong to discriminate against someone for disability and say they can't serve on a jury. But why is it wrong if the court still says you have to look people in the eye? We've actually kept a rationale from which keeping visually impaired people off juries makes perfect sense. All right. So what do we actually know? This is our legal system. Continuing to say demeanor is critical. But we use this throughout. So we have built, not just, we have built what's the rationale of the role of juries to explain what's in the Constitution. Why should appellate courts defer to first instance triers of fact? Because first instance trier of fact can look you in the eye. Why should federal courts defer to administrative agencies? Because the administrative agencies can look at the witnesses during the hearing. This appears throughout. We have it in in statutes, in court decisions throughout. This idea that there is value in seeing someone testify. Now, this has been hotly researched. It continues to be a very sensitive area because from law to national security to dating and sex, it would be wonderful to know whether someone is lying. But, so there's a huge market for it. If you go on Amazon and just look how to identify a liar, you'll find there's lots of books you can read. I chose this quote from Ekman and Sullivan because they are actually the main proponents of the idea that we can find some value in demeanor. But even they concede that it's mostly worthless for most people. So most studies basically find that if you test subjects, identify, and ask them to tell, is this person telling the truth based on their demeanor? Basically, they can get it right about 50 to 55% of the time. Maybe that's good enough for preponderance of the evidence. It means, though, it's little better than chance. It's definitely not something that you want to rest a lot of confidence on. And the research has also found that there are better ways to tell the truth from witnesses, much better than demeanor, which we seem to rely on so much. The main debate, Ekman, by the way, if anyone saw that Tim Roth show, Lie to Me, the Tim Roth character is based on Ekman. So you get the idea, he has a blog, and he now works as a consultant for the Department of Homeland Security. What he wants to develop is an idea that you could train someone how to use demeanor. That's the controversy, actually, right now. Some researchers basically don't think this is all a dead end, we've exhausted it. Human beings are not lie detectors from demeanor. Others, because it would be very useful, would like to find a way that we can do it. That's where the debate is. There's basically consensus, though, that if you bring 12 people in off the street, say a jury, they are not going to be good. Now, there are better ways to tell whether a witness is telling the truth. It's not a lost cause. So, but most of them deal with the content of what they're saying, whether they cry when they say it, but the level of detail that they can produce, if questioned in the correct way. Consistency with external evidence, even small amounts of external evidence. Maybe we really don't know exactly when you picked up the knife, but maybe we do have some external evidence about some other parts of the story. Just a bit of external things that we can match what you're saying with can help accuracy considerably in being able to identify whether someone is giving an accurate testimony. What's interesting about this research is it does not match up with what we do in court of law. And I think we've heard that from the way what we know about psychology can be used also to manipulate to win, which is not at all the same as reaching the right result. Because as you saw, for instance, if adjudicators expect consistency, and if by using a different word, I can get you to say 30 minutes at your preliminary hearing and get that changed to 45 minutes when you testify in court and then confront you with that discrepancy. If the adjudicator is expecting perfect consistency, it means you look like a liar. It doesn't mean you really are. It just means you have fallible human memory. Now, what can we actually do with this information, given that something that our legal system has been built around may be false? What are good practices to win cases in terms of leading questions are exactly the wrong kinds of questions you want to get useful testimony to discern whether someone's telling the truth. Well, to digest this directly would be incredibly radical for our legal system because it would seem to upend so much. And I suspect this is why courts don't really want to ask these questions, even though their clerks could find ample research pretty quickly about it. So I want to suggest two ways that we can start to integrate this into legal practice. One of them, we heard this about trial witnesses already, maybe jury instructions. So in Perry v. New Hampshire, Supreme Court endorsed in a footnote at least one of the California standard jury instructions that deals with eyewitness testimony. And it wasn't about credibility, it was about eyewitness accuracy. What's interesting in the California instruction is it takes a jury through a set of analytical steps that correspond with the research about what might make eyewitness testimony more or less reliable. Now, I don't know if there's been research on how effective this is in impacting jury results, but one idea might be to have that kind of analysis, not just here's a swirl of factors to consider, but proposing it to juries a set of analytical questions to ask. There may be some pushback from judges, though, because of that long line of court decisions we have. If you start telling a jury how to decide what the truth is, you might be taking away their sacred role that's enshrined in the Constitution. So it may not always be the easiest route. And we still have a lot of research to do about what impact jury instructions have on juries anyway. I want to suggest that a good place to start, though, is in the administrative context with executive agencies, where we also have high-stakes findings of fact, but not by courts, not by juries, by agencies who exist in part because they're supposed to be experts at what they do. And so agencies should be better able to digest new research, more than judges and courts in a way. And so let's come back to my field. In refugee adjudication, we may be, I think, fairly advanced in doing this, at least in some countries, because since the 1980s, there's been an evolution of training that integrates the psychological research into training adjudicators on how to question, what kind of answers to expect, not using leading questions, not using close questions, doing everything opposite to the way a good trial lawyer would do it. And also understanding what's our level of comfort with doubt, not only trying to get the right answer. This is anecdotal, it wouldn't pass muster with perfect scientific study, but it's the best you can do. As countries, as governments have integrated this into training standards, the acceptance rate of asylum applications has tended to go up. There may be many reasons for that, but there's definitely, this is a case where the evidence is consistent with the hypothesis, and I can't say any more than that, that it has an effect on impact. And just an example of this is something that I was involved in, but this is a new training manual that was just produced that will start being used this year to train new asylum adjudicators in the European Union. And that's very fuzzy, and you can't see there. The authors are a mixture of lawyers and psychologists, so it's a successful area of bringing together exactly what this conference is about. And in a field where it can be accepted without high court worrying that you have just upended everything we know about law. So that's it. And before I get to stage.
So we do have several minutes for questions, so ask away. Yeah.
I have two questions for Dan. Very interesting study. I'm curious about two things having to do with your research design. One is, if I understood you correctly, you're comparing the effect of instructions before testimony and after testimony. And I'm curious why, because to my knowledge, giving jury instructions before testimony is very rare, if non-existent, in practice.
The reason we did is because prior research involving children and child witnesses shows that before is actually more helpful. We didn't find that here, but prior research does find it is more helpful. And so I'd like, with everyone here, like the goal of the research is to make a difference in the actual judiciary.
But does it, my question is, does it take place in the real world?
In the real world, not yet.
Yeah. second question, obviously you were trying to study a variety of variables and a different approach would have hindered you in your ability to do it. But I'm wondering if you have concerns about the validity of studies that look at stills, pictures, as compared to a 5-minute extract of a child witness testifying about a traumatic event.
Of course, the external validity is an issue with any type, which is why highlighting the pictures is so important in a study like this. When you're dealing with emotion, and you want to make sure that the emotion is conveyed, you want to make sure those pictures are conveying emotion. So one of the things we looked at that we didn't talk about here is we asked participants to then rate after the whole study how they believe the victims were, what was their emotionality after reading the scenario, making a judgment. And they did show that basically the sadder kids appeared sadder. So in some sense, we know for sure that the participants did absorb the information about the emotion. However, whether that is conveyed in the decision-making the same way it would be if you saw the child testify in front of you, that's an empirical question, and one way to do that would be to have child actors, and there is research, not with emotion, but that have used child actors and filmed them use rooms like this, and they're great studies, but we had to start somewhere. So this was where we were hoping to start.
My question, I guess, would go to maybe Michael or maybe Deborah, or maybe Ann. I always thought there was something pretty specifically unique about tears and crying, and thought, and tell me if you agree or disagree, but that we respond differently to tears. Some people, for example, become immediately empathetic, or it can cause them to want to try to help, and certainly to believe. But I think other people become immediately cynical, and they think that the person who's crying is crying because they're lying. And so there's just this immediate difference in human nature, I think, as a response to tears. But I don't know if that's based in any research, or if you've heard of that theory, and if it is true, how do we account for that in terms of trying to then piece out the impact of a jury instruction when people respond to tears differently if they do?
Well, I don't know the research about tears, but I think you raise a very good point in terms of the differences in people's reactions, and I suspect that in addition to just the variable of tears, there are a lot of other things going on. I think people will respond differently to a child versus adult. I think crying is very different when it's a woman crying than a man crying. And then we have a lot of research that's across the board. Social and economic status impacts believability. As you heard, I'm more believable to a jury in New York than in Texas. I think research to back that up. I think that's reality. White jurors are less likely to believe black jurors. Good-looking people are more believed. I don't know if there's research on what happens when good-looking people cry. But it would not surprise me if you find significant effects, none of which will correspond to what's actually true.
Well, to address the part about the research, so one of the issues with emotion research is in this field is that they don't often look at level of emotion. We did by using 3 different levels of emotion. And as you saw with emotion absent, we did see that crying was less believed than sadness. Whether that's a distrust of tears, we don't know the mechanism exactly. There was one other study done by Gordon that we cited earlier, also showing that he had 2 levels of tears, and hysterical crying was not believed as much as just regular crying. I believe he used line drawings, like sketches for his stimulant. But so there could be something said. Though evidence, we do have points of the possibility that tears do in fact lead to some people believing it, whereas some not, and what we're seeing is just an average of overall less credibility. And there are ways to get more at that. We have some individual difference measures that we'd like to look at. I mean, we have a large data set here. This is just one small piece.
I'd actually like to do the paper when good-looking people cry, because the title will be good. Hoping that I don't want to find models for it. But that all being said, yeah, I was smiling when you asked that question, because it's something we've talked about, and something actually that I'm interested in ecological validity-wise is that at a certain point, judges shut it down, right? When a child, especially with children get too hysterical, when all witnesses get too hysterical, they shut it down. And so one thing that Dan and I tried to do here was make sure that we had 3 pictures that displayed different levels of emotion, but didn't go to the point where I thought we lost ecological validity and the judge would have just put an end to the testimony. Something that we thought was could be displayed on the stand but wasn't overly stated. I think there are a lot of emotional, social, and social cognition theories that could fold into why tears are interesting. Something we've actually tested, and hopefully we'll be reading fascinating paper a year from now. Stay wide and think about it.
Arnold?
Yeah, I have a question primarily for Sydney, possibly Sarah could answer partially. As far as the manipulation strategies in your talk, while they seem, the data shows they're pretty powerful, do you think you run the risk of it being too obvious when you do that and a jury holding that against you? Or with Sarah's example of a child sometimes being able to be persuaded, their memory to be altered by the way you ask a question, what color is the hat he was wearing, and they make up a hat. Do you think that strategy is obvious also to a jury and they'll hold that against you, or is there a way to?
I think it would depend on the jury's level of understanding of child development. And so I think it would go to that. And I would venture to say that the majority of jury members do not have a high level of understanding of those subtleties about child cognition and child emotion that would go into that. So I doubt that the technique would be overly obvious unless it was revealed to be what it was. But even if it was revealed to be what it was, I suspect that it would be interpreted more against the child and the child's credibility than against the attorney doing it.
I think really, to me, it comes down to the particular scenario. What I mean by that is, I think that the reality is most people have no idea that they're being manipulated. And I think in a trial setting, the answer to your question is absolutely not. They have no idea. But change the scenario a bit. If you're looking at a recorded deposition, right, that is a trial where you or your expert, your psychologist can pick apart privately and watch over and over again, and then use that sort of pre-recorded deposition in trial to talk about the manipulation, I think the answer changes. Because then you can say, well, you asked the question this way, and sort of tie it to manipulation. The reality is in trial, doesn't happen. And that's in the real world, one-to-one doesn't happen. Even in the deposition, not going to happen. But when you have time to review it later, then I think you can pick it apart.
Some evidence of that was that we knew that Sid was going to manipulate us when he got up there with the 3 coins. I was listening carefully. I knew he was going to manipulate us, and I still didn't get it. More questions? We've got some more time.
Yeah. Michael, I just wanted to ask on the demeanor point. Much of the presentation that you gave was about the observer interpreting the demeanor of someone who's on the stand. There's also some interesting recent research that suggests that there might be variations in the kind of micro-behavior and demeanor of the actor in context. And this is based on the literature on stereotype threat and the idea that this is suggested by your paper as well, the idea that members of low status groups of some racial categories or national origin, perhaps in the amnesty context, may feel like they're going to be valued based on their group identity in that particular context, which would lead them to be more nervous and have different demeanors. So you could kind of go at it from both angles that way.
Yeah, I think that's right. I think actually what's interesting in the research is it's not as if there are no physiological, observable impacts that are connected potentially with lying. So for instance, there is evidence that people's voice, pitch of voice goes up slightly sometimes. And there are some other things. All these things come from muscle tension. But it's not measuring lying, it's much sort of measuring tension. And so yes, it will correlate with lying because people may be more tense when they're lying. They're also more tense when they are just testifying, or when an uneducated person is testifying in a foreign country and they feel their life is at stake. It might be a little tense. And so it's not very useful. And I think this is why this is like for instance, the Ekman has been involved in efforts with TSA to use interviewing like this and then for TSA screeners to see if people are nervous and maybe should be pulled aside for further questioning when boarding an airplane. And the idea, of course, is to catch a terrorist, but mostly they do a lot of racial profiling, and I mostly catch Arab people who have fear of flying.